Hi, I'm Janice Switlo, and a number of people have approached me asking my response to the defenses that are being pursued, where there have been people charged for having possession for sale of cannabis off reserve, just on a road entering into, for example. And today I'm going to go through in some detail the Notice of Constitutional Question dated August 8, 2019, and then amended an addendum to the Notice of Constitutional Question dated January 21, 2020. And the applicant is David Brennan. He's one of the charged. And the lawyer on this is Michael Swinwood. Now, I want to, just before I start into the details of the documents, point out that I have a bit of an issue here with how Michael Swinwood is conducting practice of law by calling his law firm Elders Without Borders. Now, in 1998, William Commanda actually he organized Elders Without Borders, which was a gathering of elders and spiritual leaders from both North and South America. He's since passed on, in 2011. And it appears, and I may be wrong on this, but when you look and try to look into Elders Without Borders, it consistently comes back as, for example, the Law Society of Ontario, that this is his business name. This is under what he practices law. And any further attempt to understand what this structure is, it suggests that there's a staff of two. That may be him and another lawyer, or him and a secretary. But it appears that he, this is his law firm. And the email address he uses is spiritualelders@hotmail.com. Now, that's kind of like me, and he's gone through a process of being instructed, including by William Commanda and other elders. He took a sabbatical from the practice of law to observe and hear from elders. But, that would be like me. I make commitments in Longhouse, and me calling it the Longhouse practice, or the Longhouse, the Longhouse, right? I have an issue with the use of that term, because it, quite frankly, can have the potential to mislead, that people think, oh, he's acting for elders. And yes, he does have clients who are elders, but this is not an elder organization from what I can find out. And of course, with a law firm, you can't just have anybody under your law firm either. There are rules about that in terms of what law societies permit. And I also want to point out, before I start into the specifics, how he sees things, what gets him excited, if you will. And I'm going back to as an interview, and it says, in 2014, in what's considered a historic ruling, the Supreme Court of Canada unanimously decided to give Aboriginal title to more than 1,700 square kilometers of land in British Columbia to the Chilcotin First Nation. Swinwood said the BC case defined new standards for Indigenous law, and he will rely on those legal principles to fight in this particular case. It basically, quote, it basically suggests that any claim for Indigenous title or Indigenous rights is no longer just decided by the common law, end of quote, because there's a case decision. Now, he's talking about Section 35 doctrine. And his reliance on the terminology and use of Section 35 is throughout this Notice of Constitutional Question. And do forgive me as I kind of go back and forth. Oh, sorry, there's one other thing I wanted to mention about his background that I've been able to obtain, and that is that he is apparently a consultant for the for IHRAAM. Now, their full name, although they go by the initials, the full name is International Human Rights Association of American Minorities. Now, I was approached by this organization myself, and it turns out it's one woman in an apartment on Vancouver Island. And it was her late husband, a black man, black American, who was pursuing issues as a black minority. And I found that this organization, which was essentially now there's just this one woman, the widow, was fundraising on the backs of, for instance, Idle No More women. I won't name the woman, but they sent her to Geneva, and they had approached me to rewrite or edit, I should say, the what this woman had prepared. And it turned out, I had to, the only thing I could say from 4 pages was literally one sentence. And it was very disappointing when this woman who was interviewed in Geneva, an opportunity to make some points, was unable to discuss the situation of Indigenous nations in the context of international law. She was, the reporter asked about an international matter that I would, if I were asked the question, I would have gone on at length and showed the comparisons and differences. But this person who had gone to law school, I believe, wasn't able to address because she didn't have that foundation in international law. So he's apparently linked with that. So that's kind of the front ending of, and it's important when you're dealing with someone to find out what have they been involved in, what are they doing, what is their message, how consistent are they in the principles that they're supporting, and how are they moving those principles forward? Are they achieving anything, or is the situation getting worse? So turning now specifically to the notice of constitutional question. It's clearly he's talking about section 25 and 35. And speaking of, there's some interesting points, some interesting documents that, he does point out about earlier proclamations. But anything that might be interesting there to pursue, he is completely undermined by the section 35 approach. And I, with the greatest of respect, his perhaps not fully appreciating that doctrine. And I'll explain what I mean by that as I go through this. So he's saying that where these cannabis dispensaries were located were on unceded land of the Mi'kmaq, Algonquin, Anishinaabe Nation, of which David Brennan is a member. Now, keep in mind, one of the things you always need to do in any legal document is be absolutely consistent about the party you're talking about. And, we have Aqua Nation, we have Mi'kmaq are neither Indians nor Aboriginals, but rather fall under the definition of other. We have, and please spell check your documents. It's really not, if you're representing Indigenous nations and nationals, do that respect. Spell check your document. Anyway, so then, all these other things. And then we have, their Anishinaabe peoples. Keep in mind, peoples don't make treaties, nations do. Then you got Mi'kmaq, Anishinaabe Nation. Like I said, there's about 5 or 6 different ways he appears to be referring to the same entity. Clean that up. I mean, let's be, as a first stage, because what you're trying to do is convey an argument that can be easily followed, and this is not easy to follow. So here in a nutshell, right, he's saying you don't have jurisdiction, so you can't charge these people. But then he's relying on jurisdiction like Section 8 and Section 7 of the Charter. He's also calling Section 35 of the Charter, Section 35 as being part of the Charter, but Section 35 is outside of the Charter. It's in Part 2. It's not part of the Charter of Rights and Freedoms. There's a lot of those kinds of examples. But you can't say there's no jurisdiction and rely on Section 35 the doctrine of which says you have jurisdiction. Section 35 says underlying title is in the Crown. If the Crown owns the land, guess what? The Crown has jurisdiction. He's saying here, well, it's unceded, it hasn't been ceded. Well, there are a number of ways that you can abandon your land, and that includes relying on Section 35. Section 35, the doctrine says the Crown doesn't have to acquire title. The Crown is simply asserting jurisdiction. And we have, he's quoting also from Missing and Murdered Indigenous Women and Girls, the National Inquiry. And it's indicative of how he views things, because he's quoting this. You would never see me relying on this, for example, because I know these to be indigenous nations with their own laws, with continuing existing sovereignty, including economic sovereignty. But here he's quoting that the principle that indigenous peoples have the right to govern themselves in relation to matters that are internal to their communities, integral to the unique cultures, identities, traditions, languages, and institutions. And he speaks about, and actually the sentence doesn't quite work, but he says, and respect to their special relationship to their resources. That ought to have been clarified, but my point here, and I guess with respect, that's not him writing that, he's quoting from the report from the National Inquiry. But the point is, he's accepting that the limit, this is the domestic dependent nation concept that America, the United States, uses. That is not the situation here in Canada. There were no wars, no conquering. That does not apply. There was no giving up through treaty. There was no waving of the white flag and saying we give up and please just let us continue to govern these internal matters. But that is indeed a reflection of the Section 35 doctrine. Quoting a statute of Canada, but yet saying not having jurisdiction. And of course, brings up genocide, quotes Convention on Genocide. Yeah, fine, but how does that defend against charges, brought under the criminal code? And it's important to remember this, under Section 35 doctrine, even if, and I'll explain why they can't, even if they can prove an Aboriginal right under Section 35, under that doctrine, Canada has the right to infringe upon that, all completely to the point of not being able to exercise the Aboriginal right. And what is a basis upon which that infringement can happen? Safety. And if you look at the Federal Cannabis Act, or what, it set out right in there. It's all about safety. So preemptively, the Act has said, we're passing this law because we're concerned about safety. So even if they successfully prove a Section 35 right, Aboriginal right, as that doctrine defines it, have to understand that Canada's already anticipated that and covered it off through how it crafted its legislation. So, he's speaking about members of the Amiqua Anishinaabe Nation have a right to recognition of their laws, practices, traditions, and customs, through both the prism of domestic and international law. Well, you're either domestic or you're international. And again, you have, and it says not acquired jurisdiction over the territory, but Section 35 says Crown just needs to assert, and that's what's being done. And what bothers me is the past tense that he uses. That undermines your argument significantly. The people were known as, the territory included, it extended. The members were traders and medicine men. My goodness. One of one of the fundamentals of Section 35 is it has to be existing, right? Speaking in the past tense does not help at all here. And even if it's an active practice, as is said here, as I said, he hasn't overcome the fact that it can be lawfully infringed for purposes of safety in accordance with that doctrine. Again, we're not talking about economic sovereignty here. There's no doctrine that can infringe on the economic sovereignty of Indigenous nations. And I have no idea why this is put in here, but again, remember that safety concept, right? And again, some of the safety, you see all sorts of commentary about how young people's brains are affected by the use of marijuana and things like that, right? And there's a reason all that stuff's in media, apart from, you know, the serious warnings, if you will, but it's also part of the paper trail that says, yeah, there's a real need to look at the safety, and Canada's doing so. And even if that infringes upon a Section 35 right to sell, that's okay under the doctrine. The example here is speaking about, you know, the land is full of hemp, and natives use wild hemp, quote, to tie their bone fish hooks. Public safety for use of hemp to tie the bone fish hooks is not going to be an issue. But of course, that's not what the Section 35 right they're trying to achieve here. They're going to offer evidence, you know, that this constitutes a Section 35 Aboriginal right. And then there's reference to the United Nations Declaration on the Rights of Indigenous Peoples. It says, hey, that means we have the right to carry this out. But what he fails to appreciate is that UNIDRIP also says that Canada decides, the member UN state decides how things are done. And Canada was the pilot project. Section 35 is how it's going to be handled. So that's not helpful for them. Then here's remember the past tense, right? The members of the Amiqua Anishinaabe Nation will also advance arguments that suggest that the relationship between them and the British Canadian colonial governments, remember, relations are between the Crown and Indigenous nations, but under Section 35 doctrine, the relationship is government to government, because if it's pursued as a self-government right, that's all within and under Canada. Is one informed by genocide and apartheid and must be taken into account in the evaluation of their laws, practices, traditions, and customs, that's straight out of Section 35, which were destroyed by colonial policies designed to impoverish Indigenous peoples and lead to their eventual elimination. So he's admitting they've been destroyed. Not unlawfully interfered with, but no, destroyed. And again, remember that operative language in Section 35. Again, I don't, as you know, I don't endorse proceeding anyway under Section 35 unless you're an ethnic minority. But if you are, for goodness sakes, you have to be saying, we did it before, we were doing it again, we'd still be doing it, but you're interfering. And you can't justify that interference under this Section 1 equivalent that the court has imposed and inserted into the Constitution through these Section 35 cases. So basically, what this comes to say is that, these people, they're occupying, but they're lawless. There's no more Constitution because it's been destroyed. There's no spiritual ceremonial. And again, how is that going to respond if there are no continuing laws, no Indigenous laws still operating? Then even more so, let's leave apart the Section 35 for a minute, even more so in that lawless state, Canada is enforcing its laws, criminal code laws, in cannabis law. And moreover, the Section 35 doctrine says clearly this is Canada's jurisdiction. So, like I said, while there's a couple of documents that prove interesting, there's really no point in having them in here because everything's conceded under the approach, under Section 35, and as I said, failing to appreciate the significance of what Canada can do under the auspices of providing a safe environment for the sale of cannabis. Now, this is not to say there are no defenses, there are no ways to approach, but this is certainly not an approach that I can endorse, nor would I recommend. And that's all I have to say.